So thank you very much, Boris, for those kind words and for handing over to me for just a brief period of time before I and sort of the rest of the panel will sort of rotate out and sort of make room for others to follow. With me on the panel, two further distinguished practitioners. Katerina Fulier here on my left-hand side is a partner at Babic & Partners in Zagreb. And we'll be covering a number of topics specifically concerning Croatia. And I'm happy to have Gabor Fejes, a partner at Oppenheim in Budapest, to my right, who will do the same thing, looking at our subject matter from a Hungarian perspective. If you look at the program, the subject matter is defined as cartels and leniency in a cross-border setting. Now, one thing that we're not going to do is to tell you all about running cartels in a cross-border setting. That is, I guess, for another panel, and I also guess for another conference to do. We're going to look at the consequences of sort of cartels and sort of the investigations by authorities in order to uncover those cartels and apprehend those involved in them, with a particular focus on those investigations that cover more than one jurisdiction. We look at what needs to be done by sort of the companies involved when they are faced with an investigation. And actually what we're going to do is both slightly more narrow and slightly broader than that, because what we will say here does not only apply to companies who are faced with an ongoing investigation, those who sort of have the commission or a competition authority knocking at their door and doing a dawn raid. It also applies to those companies who realize they have a competition issue, they realize they have a potential cartel in their closet, and are considering what to do. So very much the same considerations apply in a pre-investigation stage, with the difference really being one of timing. You may actually, or you may not, have more time to consider your options. You may not have the time because there may be others who are thinking about the same things, but the considerations are very much the same. In the same way, what we're going to say here on the panel also applies to purely national investigations, because the steps you go through are the same, the structure of the investigation is very similar, and the points that need to be considered are the same. Basically, the assessment is slightly more straightforward. It lacks the international complexity, but the steps are sort of very, very similar. So with that, having said that, we would like to sort of launch directly into sort of our discussion here. We've shared the burden a bit. I will first sort of give you a brief highlight over the framework at European EU level and member state level. And given, as Boris pointed out, that I'm a German lawyer, I may actually draw sort of from some experiences, especially in the German context, working with on the other side of the Bundeskartellamt. I will then sort of have a brief sort of run through the things that sort of the parties who are faced with an investigation may want to consider on their way to developing an antitrust strategy. And then it's Katerina who will sort of supplement that and provide the current view from Croatia, and Gabor will look at Hungary, as I said. So, without further ado, as I said, my presentation basically a brief view of the legal framework at European level and at member state level, a one-page run through the life of an investigation, and then basically the main point, how to manage a multi-jurisdictional cartel investigations. Looking at the European framework, you realize the prohibition of cartel-type behavior is contained in Article 101 of the Treaty of the Functioning of the European Union, but also in national competition laws, which very often mirror, very closely mirror, indeed, the prohibition contained in Article 101. We are, for the purposes of this panel, looking at what's commonly referred to as cartels or hardcore restrictions that attract investigations and potentially high fines. What we are looking at in this context are the classical cartels, the price fixing, the market allocation, the customer allocation cartels. But what we're seeing increasingly is the prohibition being applied to also softer cartels. And that actually seems to be happening at a time when the major cases in Europe go to the European Commission and are considered there, and national competition authorities are trying to sort of consider what's left for them. And as we've heard sort of in the opening keynote speech, those may be the purely local cartels, the sort of price fixing amongst taxi drivers in Zagreb type of cases. I don't know whether they actually do that, but they do in Budapest, no? Well, sorry. At any rate, those are left for the national authorities, but you also have the softer types of cartels, if you will, information sharing, competitors who get together for a little chat on a sort of, twice a year just to see how the business is developing, what the customers are demanding sort of outrageously, and how one should sort of respond to maintain sort of fair competition. That's the kind of case that's also covered by Article 101 or the equivalent national rules, and that are picked up by national authorities increasingly. What happens if you're caught? There are sanctions. There are sanctions at European level, where administrative sanctions, non-criminal sanctions, as the Commission is always keen to point out, are levied against companies. It's always sort of difficult when you're faced with an investigation to say exactly what is it going to cost. There are fining guidelines both at European level and at national levels that provide some clarity, and I'll come to that a bit later, sort of the calculation of the fine, but they do not always give you the full picture. A lot actually sort of depends on how investigations are run, how keen an authority is to sort of pursue certain cases, and how keen it maybe is to settle sort of a case. More on that later. But sort of the key message is fines are significant, and that's why companies tend to think about ways of reducing them. Immunity and leniency are the key tools to do this, besides not entering into the cartel in the first place. Sort of they've been a key tool for competition agencies in sort of to uncover cartels, because they are attractive to the companies, especially to the ones that come in first and get maybe full immunity from a fine. But having said that, the fines have been increasing for a long time. The Commission, the European Commission, is keen to point out that they seem to have plateaued, but they're unlikely to go down at European level, and they're likely to continue to rise at national level, I'm afraid. At member state level, the basic approach is similar. The prohibition and similar prohibitions apply, generally outlawing hardcore infringements. There do exist some differences, which it is important to keep in mind. At European level, only companies are fined. At national level, very often you have fines for individuals. And they may be non-criminal administrative sanctions, as for example in Germany, where you have sort of an Ordnungswidrigkeit, sort of a monetary fine for many cartel offenses. They may, however, also be of a criminal nature. And the UK has been in the forefront of promoting sort of criminal sanctions. It's still early days, but this seems to be the way things are heading. And of course, it increases the exposure and it increases the risk. It's one thing for a company to pay a fine. It's quite another thing for employees and executives to actually sort of spend time in jail. So the pressure is on sort of the companies and those involved in illegal behavior. Again, it's been pointed out earlier today that the European Commission and national authorities tend to share their work. The big major international cartels end up with the Commission, and that includes those that are truly global in nature, as well as those that affect sort of a number of member states, 3 or more. The Commission usually looks at it. Others are sort of governed by national law and are pursued by national authorities. And that actually makes things difficult in a multi-jurisdictional context because for all these investigations, sort of national procedural laws may apply and national procedures may apply. So you actually sort of have a very sort of complex system in which to work. And one thing that has also been pointed out, private enforcement becomes more relevant and needs to be factored into sort of the equation when you decide what to do in the case of a cartel investigation. Because follow-on damage claims are sort of almost automatic these days, and the exposure, the financial exposure they give rise to may be very significant.